Welcome everyone to class or collective action in arbitration. Um, so I was just saying with regard to the title, I think mass claims probably would be the more appropriate way to look at this. But of course, there's other mechanisms which we'll talk about, like consolidated claims, which is more of an artifact of treaty procedure under specific treaties like the NAFTA, and we'll get into that. But let me, before I make some opening remarks, let me introduce our fantastic panel this afternoon. In no particular order, we have Dr. Kabir Duggal, who's an attorney at Arnold and Porter's New York office. He's an old friend. We've taught together at Columbia Law School, where he continues to teach. He's involved not only in international investment arbitration and has had long experience working in that field. He has experienced in international commercial arbitration as well as public international law matters. And he serves not only as counsel, but as arbitrator and mediator. He is a recognized chartered arbitrator by the Chartered Institute. And in addition to his teaching at Columbia Law School as a lecturer in law there, he's an adjunct professor at Fordham Law School and a course director and faculty member at the Columbia Law School Chartered Institute of Arbitrators comprehensive course on international arbitration. So it's great to have Kabir here. He's always a welcome participant in Washington Arbitration Week, and we really appreciate you being here, Kabir. Lisa Snow, who's to my left here in the room in Washington, is a managing director at Kroll, not Crowell, but Kroll with a K, Kroll. Everyone gets those mixed up. She's a leading independent provider of risk and financial advisory solutions. And for over 20 years, Lisa has served as a consulting and testifying expert, specializing in financial damages, business valuation, and forensic accounting issues. She and her team, and some of them are here today, work across a broad range of industries, including financial services, telecoms, construction, and products. And it's great to have Lisa here. Thanks very much for taking your time to be here. Matthew Drossos is a partner in White and Case's international arbitration and litigation practice groups, and he's two over on my left here in Washington. He represents clients, including both corporations and sovereign states, on matters before the ICSID, the ICC, Geneva Chamber of Commerce, the Court of Arbitration for Sports, and the U.S. federal courts. Apropos to our topic today, his representative matters include the Abaclat case, which involved mass claims on the sovereign bond sector, as well as other investor state and commercial disputes spanning mine, gas, and construction sectors. And last but not least, we're really pleased to have Rob Huston here today. And he has many capacities, but today he's appearing in the role of executive director of the Global Pro Bono Bar Association. And this is a really interesting group of folks. It's a nonprofit organization, 501c3 nonprofit organization to be precise, that is currently working hard to explore potential for investors of limited means to advance mass claims against the Russian Federation as a result of Russia's economic measures imposed on foreign investors from, and I have the quote, unfriendly states, unquote. So in private practice, Rob has also represented investors and sovereign clients in international investment arbitration or other matters involving public international law. So it's great to have Rob here. Matthew, thanks for coming as well, and Lisa and Kabir. This is going to be a great panel. Now, as just to continue on in my introductory comments, I think we'll probably use the term mass claims. And again, one of the key common elements here is that sometimes you just don't have a single claimant, and you have a number of individuals, whether they may be shareholders perhaps, or in the case of the bondholder cases, bondholders, or individuals who've been affected in a common manner that might merit a common proceeding. And really, this follows some fundamental objectives or principles in arbitration. Efficiency being one. The idea that we want to minimize time and costs, and in multiple proceedings that could be, very expensive if you had, say, a dozen or hundreds or even thousands of potential claimants. Having parallel arbitrations running would be exceedingly costly, and frankly just wouldn't happen. And the other main objective, of course, is to avoid contradictory and inconsistent decisions. The idea that you might have all these arbitrations running in parallel and then all coming out with different decisions would also violate kind of fundamental ideas in law, the idea of supporting consistency in decision making. So historically, these objectives have been addressed in a number of ways, and we don't have to go back too far, maybe 100, 150 years, to some of the claims commissions that occurred in the early 20th century, the Venezuela and Mexico claims commissions, and as well, even more recently, the Iraq UNCC claims commission, and even the Iran US claims commission, which began after the Iranian revolution. And frankly, that commission is still operating. And we're going to have Kabir talk a little bit about the historical context. Another solution was found in the early 1990s in NAFTA. The Article 1126 of that treaty has what's called a consolidation provision, which very explicitly the NAFTA parties sought to deal with those situations in which there might be multiple claimants, and that issues of efficiency and overlap in terms of subject matter made sense for those cases to be consolidated. And there's been a number of those cases as well. And of course, and I'll comment a little bit about that as we go through. As well, there have been other creative approaches, and we've seen primarily at ICSID, which doesn't have arguably explicit provisions for consolidation. But we've had, one of the largest cases ever, the Abaclat case, which Matthew is going to dive in to, and it went on for many years, and really helped draw out and illuminate a lot of the thinking behind the idea of how mass claims might work. Even in other cases, not other than Abaclat, even in smaller cases where there might have been, rather than 60,000 claimants, there might be 2 or 3. Tribunals have taken more creative approaches, and appointing similar tribunals sometimes is the approach, while still running separate claims. There's really kind of all sorts of different ways that tribunals have come at this issue. And you can really see the avoidance of parallel claims, the avoidance of multiple claims. It really meets a key objective that we've seen in other parts of international law and international practice. And we look at, for instance, the concept of res judicata, and the idea that if you have overlapping subject matter, overlapping parties and remedies, that that is an argument for either shutting down one case or combining them. So another issue that's come up, and this was, I think, one of the reasons the NAFTA parties put a consolidation provision in their treaty, is the question of consent. How do you and respondents will argue this, is that they didn't consent to that consolidation. And that issue does come up, and Matthew may touch on that. But I even have an anecdote of one case that I did many years ago, in which we had an interesting situation. The respondent was the same, so there was one respondent, but there were effectively 3 claimants, a parent and 2 subs. But the 2 subs owned 2 different properties that related to 2 separate licenses that were required for a single mining project. And this is a case called Con versus Mongolia. And so we had basically 3 claimants three bases of jurisdiction. We were able to bring expropriation cases under the contract, which had, interestingly, an expropriation provision, under the foreign investment law, the local law, as well as the Energy Charter Treaty. So we had these multiple bases of jurisdiction and merits. Luckily, they all called for uncial rules. So we had a good argument on the procedural side, but of course the argument came up in the arbitration that, well, no, this is three separate claims. You should run three separate cases. And luckily we were able to negotiate that and get the consent of the respondent to put this into a single case, but ostensibly there were three claimants, even though they were related parties. There was enough distinction in terms of there being separate claimants that the argument was there that they should have been three cases. So these kind of issues arise in all sorts of different contexts. And I think that's my signal then to move to Kabir first. And Kabir, provide us a bit of context and a little bit of historical background, because this is not a new issue. This is one that's been used throughout in the earliest days of international arbitration. And of course, Kabir has an interesting starting slide. So take it away, Kabir.
Sure. Thank you, Ian. Delighted to be here with a lot of familiar faces. I'm going to provide the historical context about how these things have worked out. And let me just give you two thoughts to think about, because as you are looking at what we're talking about, think about how effective or successive these commissions have been. And there are two ways you can assess them. And this is significant because this idea of claims commissions from Ukraine are floating around for many quarters. But there are two ways we should be thinking about them. Vision one to do the assessment is really individuals and individuals getting a voice. That's one way we can assess them. Most of the commissions are effective if we're looking at it from that perspective. Issue two, are we solving the underlying problem? And pretty much every claims commission from that perspective has been a complete failure. They have only resulted in worse things historically coming out. And that's really another way you can be thinking about this. So let's take a look into history. You have this major war that takes place between two countries, and suddenly you have the independence of this small country, the United States of America. And at that stage, relationships with the former mother country, Great Britain, are not great. No pun intended there. And you see in the US history, the negotiation of one of the most polarizing treaties. So if you think things are bad in the past couple of years, well, we have a rich tradition of no one agreeing on anything. This is probably the single moment in the US history where George Washington was attacked in the most unflattering manner. And this is the negotiation of the Jay Treaty, right? Now, what's unique about this treaty? This treaty actually provides for arbitration in the form of mixed claims commissions, not for one, not for two, but for three separate sets of things. You have one with the dispute in relation to the border. Ian, thank you. We're talking about Canada. There's a mixed claim commission that's going to be created to look at that. The second, the French really supported the US in the Revolutionary War. Obviously, Great Britain didn't love that. And when the ships were passing across the Atlantic, American, and the notion of who was an American was a big question mark, but there was a lot of ill treatment in the mind of the patriotic Americans on their shipping rights. So that's going to be a separate commission that's going to really address this issue. And then you see, relevant to what we're talking about, debts being owed to British merchants, and these debts really not getting paid. And we're looking at, albeit in different terminology, we're looking here at the creation of a commission. There's a lot of antiquated language, but it's going to be two by each state, and then a president, a commissioner, I think that's the term that they use, that's going to resolve these disputes. So here you're seeing again this idea that individuals can bring their claims before this commission, they can get them heard, they can get them resolved. And pretty significant things. You're talking about borders, you're talking about shipping rights, you're also just talking more basically about commercial rights, rights of investors. We put a fun fact here. This did not work out great. 1812, there's going to be another war. Washington, D.C. significantly, the capital is going to get burned. A lot of the art and the artifacts are going to get destroyed, and a new treaty is going to be signed. So again, probably not the worst idea to have done this treaty. The historical assessment is a mixed bag. Let's look at another treaty, and this is a treaty that's going to be signed between the US and Mexico in the 1920s. This is the time when there's a lot of revolutions happening in Mexico, a lot of US in the minds of Mexican. They're seeing a lot of US interference. American citizens in Mexico very concerned over the fact that they're being treated hostile. And there is a creation of a mixed claims commission to address all these issues. You're talking about the Constitution just the way we would understand arbitration 1-1. You're going to then have a precedent. You can here actually see the PCA making a happy appearance. That is, if we have a stalemate, it's going to be resolved by the PCA when it comes to the constitution of the tribunal. How did this commission work? Now, some of our famous cases, Ian, I blame you / give you credit for finding some of these early cases and putting them in Near versus Mexico, right? The bedrock case for minimum standard of treatment. It comes out of this body, so significant for our case law. Again, if you're doing a historical assessment, the historical assessment is fairly poor. It didn't solve any of the underlying problem. It had to be abandoned in 1934. And the ultimate way to settle the problem was for the states to get together, direct negotiation. I'm going to get in and out of this because there's a whole host of mixed claim commissions that the United States and to a lesser degree the United Kingdom are going to enter into. Again, problems with Venezuela. Haha, sounds familiar. And we're again going to create a mixed claim commission, 1-1-1, and the empire, the appointing authority, was the Queen of the Netherlands. So fun fact there that you see how royalty had a pretty significant role to play when it comes to resolution. So just thinking more generally about who the appointing authority should be. We have fortunately moved away from royalty into arbitral institutions, but these are significant positions, right? Who do you put to decide these complex disputes? If present history is and present reality is any indication of how things are in terms of the US-Venezuela relationship, I think I just rest my case with that. We then look at the hostage crisis that takes place in Iran. We're going to see the hostages in Iran, and we're going to see the freezing of Iranian assets in the United States, and a variety of court actions taking place all around the world. And here's where we see Algeria stepping in, really offering good offices with the Algiers Accords. And the idea again here is to settle the dispute through arbitration. They're going to create a framework for resolving the dispute. the court is still the Iran-US Claims Tribunal. The body that comes out of all this negotiation is still an operational body. It is continuing to resolve disputes. It hasn't addressed the underlying relationship between the US and Iran. And this is documented realities. A lot of these cases have been political as opposed to legal, and they've been fist fights at the proceedings in The Hague. So we will take what we can get from a rule of law and judicial process, a mixed bag. Finally, we look at the invasion of Kuwait by Iraq. The Security Council, the body that under the United Nations Charter is authorized to deal with peace and security. And I just point this out because this is the big $1 million question, bajillion-dollar question in the room. With Ukraine, how are you going to get Russia, that has the veto power, really in the Security Council, really going to agree to anything? You can look at all the symbolic General Assembly resolutions, but it is symbolic for all practical purposes. But in this particular case, the Security Council resolution tells us that we're going to hold Iraq responsible. Initially, Iraq resisted. Okay, but Iraq will eventually agree. Assets are frozen, all the oil money, and that's going to be used for a compensation through arbitration mechanism. You have this scheme for 6 different people, 6 different categories of people who are entitled to seek compensation. Again, I just rest my case. If you think Iraq, I leave it to you to decide how you assess Iraq's situation today. Now, has the commission worked? More or less worked okay. The process about how this whole body was created is questionable, to put it mildly. I'm going to just stop here because while we're thinking about that, I'll move gears, and 10 seconds, I'll give it to you. Ian spoke about consolidation. This is another way we can look about it. Most bodies tell us nothing. NAFTA gives us some example. You can create a consolidation tribunal. That's how they're described in the orders that I looked at. And you're given some good criteria here. How has this worked out? It's been a mixed bag. Ian, I don't know if you would agree. I would say mostly badly. There is the Canfor case with the United States where the tribunal did agree to consolidation, but the United States has been lucky for a lot of things in arbitration. So I'll just leave that as a macro point. The general view tends to be reluctance, putting people together, their concerns, our interests don't align. Very often you want to put 3, in the case in front of you, it was 3 high fructose corn syrup producers, which is apparently a thing out there, but they all looked at each other as competitors and didn't love the idea of having to share the stage with people who they didn't really like. So this is an option that's out there. How effective they have been, we put a question mark. I just put this out there because history can provide us with some good insights on how these things have worked out. I'll probably stop here, and in the Q&A we can discuss this further, but I'll pass it back to you for now, Ian.
That's great. That was great. Thanks so much, Kabir. On the consolidation, I think you're right. There's kind of this mixed history. The 2 cases you put up, the Canfor case, I believe there was like 3 parties in that. In the corn products case, 3 parties as well. And you know, in the corn products case, I think one of the main arguments was they were actually competitors, and that actually being in a single action together and sharing information and kind of having to cooperate, they basically didn't feel they were kind of up to it. And in the Canfor case, not a similar situation. These were not parties that they may have had similar cases in that case against the U.S., but they certainly weren't related parties in any way. They were very different corporations. That being said, the consolidation was ordered. The interesting thing I find about the NAFTA context is you do have a number of other cases in which there was consensual consolidation. They didn't go through the procedure that was under the NAFTA case. In particular, there was a case called Canadian Cattlemen for Fair Trade versus the USA, and that's also known as the BSE case. This was about BSE regulation, which was stifling, I think, Canadian exports of cattle. And in that case, there were 109 Canadian companies that brought that case, and that matter was effectively run in a consolidated single arbitration. Another case is Bayview versus Mexico, which was a case against Mexico by 46 individuals and entities in that case who were making claims concerning water rights, cross-border water rights from the Rio Grande under international law, and basically in light of treatment by Mexico diverting the water. So in that case, again, it was filed as a joint group, and an agreement was reached to have that as a single arbitration as well. So I think kind of the lesson out of NAFTA is that, when you have those large groups of common elements who are effectively bringing the same case, they kind of self-elect in that case to bring a single claim. And I think in those contexts, both Mexico and the US seem to agree it just made a lot more sense from an efficiency point of view, rather than bringing, say, in the Cattleman case, 109 separate cases. It just made pure sense to bring a single case. So that's a little bit of kind of the history, historical context. I think next want to go to Matthew with a bit more recent history, and certainly a case that was a blockbuster in the ICSID world when it was first brought out. It's sometimes referred to as the Abaclat et al., and the et al. Part is truly an understatement. But I'll let Matthew kind of take us through that and the experience from that case. Matthew.
Thanks a lot, Ian, and on this, but I think it will help a little bit. Not know the details, and for people who've never heard of it, the case arose out of Argentina's 2001 sovereign bond default on its international sovereign bonds that were sold and marketed all throughout the 90s and early 2000s, and then in one mass swoop, the Argentine peso was unpegged from the dollar. A lot of devaluation and financial crisis hit Argentina, and one of the moves default on all. One significant group that was impacted by this were bond bonds, retirement income to be held by able to be used. So there were tens of thousands, hundreds of thousands of people who had significant portfolios of sovereign between That's okay. Is this one better? All right, there we go. So that effectively the link between the Italian bondholders in Argentina was the flow of funds from the Italians over to Argentina by purchasing and holding these bonds in the millions and billions of dollars. And then the sovereign bonds issued through various investment banks and then local Italian banks and institutions to their individual shareholders. And at the time of default, the value of this was effectively wiped clear, and then it was driven into place by what was known at the time as the cram down law, which Argentina instituted, which effectively said you either are going to accept our very, very low exchange rate for our peso denominated bonds, which would give you cents on the dollar and not allow people to really recover any meaningful percentage of their holdings. The merits and the jurisdiction of this case, I don't want to get into here, because more about what I'd like to do is talk about some practical takeaways that we got from the mass claims aspect. But to get to this, we had a coordinated effort of all of these people in conjunction with the Italian Banking Association to hold out from the exchange process and initiate a treaty claim on the basis of Argentina's sovereign acts at the time. And the original representation involved to the tune of 180,000 individuals. And then eventually, after several attempts by Argentina to do further exchange offers, concluded with 60,000 people. Now, what Ian was just mentioning, two of the examples from NAFTA, 109 people, 46 people, that's a lot of individual claimants. You bring it together, you initiate it. There's a lot of efficiency to not have 49 individual actions or 109 individual actions. It's equally the case not to have 160,000 individual ICSID cases filed against Argentina for sovereign bond default, which was one action affecting many, many people at the same time. So really, I think meets the definition of a mass claim, and it's one of the extremes that helpfully shows some of the practicalities that you need to face in order to make this procedure efficient and effective from the point of view of a tribunal, from the claimants themselves, for purposes of establishing liability and establishing harm and damages. And so what type of information? It's not a simple commercial arbitration. You have to jump through the added hoops of establishing nationality. Ian mentioned also consent is one of the key issues. Not only do the filing claimants have to indicate their consent to arbitrate, but Argentina itself here challenged strenuously its consent to arbitrate such a dispute with so many people. You have to also establish who the individuals are, and then key to their damages, what their bond holding amounts were when they were purchased. Was it before the default? What amounts were they held in, so that you can accurately and non-speculatively calculate damages. So a lot of information to be handled on a massive scale. And it was no longer the case where you could simply attach them as exhibits and assume that any decision maker was going to review each and every one of them and calculate it themselves, or any given damages individual was going to be faced with well over 1 million documents and multiple millions of pages in order to come up with the necessary jurisdictional hurdles and satisfaction, and then assuming liability, the damages as well. And so what do you do in such a circumstance? So assuming that you have a mass claim and then the consolidation of other arbitrations together, you have a mass amount of information. A lot of the items that we had to focus was about how to standardize information and how to consolidate it in a way that could be presented to the decision maker in such a way that those three arbitrators could render a decision and then also find hopefully with respect to damages, a specific amount of damages for all of these people, 60,000 people in the end. So you have to take all these individuals who have filed documentation, filled it out. And what we did here was create a set of standardized forms, listed out nationality information, listed out their holding information, gave signed consent on their part to arbitrate with Argentina and to be represented by one coordinating law firm and group. And then also to support that with the actual documents from the banks to show bond holdings, to satisfy the burden of proof. As I think one of the slides that Kabir put up earlier from quoting from one of the NAFTA cases, the final line read, due process is one of the fundamental issues that you have to face. And that's the case in all arbitrations, but it goes equally so if you're bringing a mass claim. You can't just say, there's a lot of people here, let's just go with assumptions, let's go with estimates, let's go with a bellwether tests. And so we wanted to, in this case, ensure that we were saying individually, we have satisfied the burden of proof for everybody, in a manner and in a way that would allow the effective review and confirmation and decision-making process on those documents. And so it was a funnel effect of taking this mass amount of information and putting it in a form, ultimately a database that was created from scratch at the time. And this is back in 2010, 2011. Artificial intelligence is not exactly where it is now, and automated procedures aren't where it is now. So you had to take those steps, working with people that do data entry and collate all this information into one usable setup. One of the things that we did, and this ties a little bit to Kabir's discussion as well, was we drew on some of these historical claims commissions. We looked back, and not so much were they successful or do these things, the underlying issues get resolved, but rather what were the procedures that were put in place? What did the UN's Claims Commission do? They standardized the application process. They created various groups for the applicants to fall into, whether it's A, B, C, D, or E. They mandated that you had to provide X amount of information for this, and then ultimately to be reviewed. We did the same thing, and then on top of it, we convinced the tribunal to appoint an individual reviewing expert who verified the database, Dr. Norbert Wühler, who sat on and participated in the UN Claims Commission. He also was involved in the Kosovo Claims Commission. And what he did is he brought a team together to evaluate every single one of the entries and the documentation there, and to confirm, back to my prior slide, that all of the evidence supported the information that was in this database, establishing nationality, establishing consent, and establishing the bond holding amount, the data purchase, and the value. He came up with a really detailed report. 88% was fully confirmed. 12% or though needed additional information, which we then provided, obtained from the claimants, uploaded ultimately to where we had over 99% verification by this independent expert for purposes of review. The tribunal there ultimately, in their jurisdictional decision, found there was consent from Argentina. There was nothing specific in the Italy-Argentina bit or the ICSID convention that restrained such mass claims in terms of consent. And then the tribunal and the expert ultimately held that there was a way to present this in a mass manner without ultimately getting to liability. The new administration, after the Kirchner administration left, decided to settle. And I think one indicative point about how this information was pulled together and presented, the new Argentina administration, in fact, based their settlement offer on our principal amount as detailed in the database, based on the evidence that we'd pulled together, and then provided a settlement offer of that principal amount plus a certain percentage that was ultimately accepted. So I think by taking these practical considerations, whether you have 100 claimants that are coming in, 1,000, 10,000, it's a scalable approach that can be used for any future claims commission or any other private arbitration, whether it's in the ICSID context or in the commercial context, to be able to apply to satisfy those burdens and really get to where you want to go, which is an award that can be enforced and an amount that can be gained. So with that, I will hand it back over to you, Ian.
Well, thanks, Matthew. I mean, that sounds like a wild ride. A lot of information. I'm going to go to Lisa next because I know she's got a bunch to say on some of the cases that we've been talking about. But I was just wondering, what was the counter argument that you received? I mean, were they arguing that, yes, you had to do 100,000 or 60,000 separate arbitrations? I mean, that doesn't seem reasonable. And the other option is you have no arbitrations. Mm-hmm. So what was the argument, and how did the tribunal deal with it? I think there was a dissent though, right?
Oh yeah, there was a dissent. So that Argentina objected on a multitude of different jurisdictional bases and admissibility bases. And really what it came down to was, number one, on consent, they did not consent to be sued by so many individual claimants. And they would say, yes, you do have to bring individual ones. They all have to put up the $25,000 filing fee. They all have to, provide all the evidence that they do, on the assumption that there's no way we would have done that, clearly. And so ICSID got over the registration phase, but this was one of the first questions faced by the tribunal, was to deal with Argentina's consent argument. And what they found was the treaty and ICSID convention being silent on such things. Article 44 of the ICSID convention, that allows tribunals to make orders and rules to allow the efficient procedure to go ahead, could make a determination on whether the evidence and the claims submitted were sufficient to be admissible before ICSID. And they went further and said, to the point that you just made, that there could be no claim. The argument is either you file $200,000 individual claims or they don't get to have their day in court. They have a treaty, they have a protection ostensibly under the Italy-Argentina BIT. But are you saying that because there's so many of them and such small amounts that they wouldn't want to individually file arbitrations, they don't get to go ahead? And so as a fundamental issue of justice and access to justice, the tribunal said this is the efficient and best way to do it that is not prohibited by the international treaties and at issue there. So they, by majority, with Tercier and Vandenberg in the majority and George Abisab issuing an extensive dissent and ultimately resigning, decided in favor of jurisdiction as a general matter. And then part of the issues for the liability and subsidiary jurisdictional issues was, did you satisfy the individual burden of proof of nationality, holdings, and liability? And then, of course, did you prove the breach as well? And that was the issue beyond jurisdiction in the second phase.
Sorry, follow up. I apologize, Lisa. ICSID has a new set of rules, 2022. Rule 46 is actually titled Consolidation or Coordination of Arbitrations. Has that new rule advanced from Abaclat, or how do you view it?
In looking at it, I think they have taken some of those aspects, but it's not completely to the tune of where Abaclat was, which was several people on the claimant side filing together originally. It goes more towards the, I think, NAFTA consolidation and other consolidation rules that you see in a lot of the ICC context or Hong Kong International Arbitration Center, where if there are similarly situated claimants, can you consolidate two different claims together? It goes part of the way there, but I think to have a mass claim, you would still need to be arguing some of these consent issues. So.
Well, that's great. Lisa, it's now yours.
I'll build a little bit on what Matt to build the proof of ability perspective of was ability to the we do as experts is to help Matt and his team figure out which, what are those ranges, right? A lot of times experts get called in and they're asked to value a claim or value an asset, but that may not really be the right point of estimation that we really need to focus on. It may be the extent to which there's the ability of the party to pay for that asset. And that's part of what was driving that difference from 2 cents to 70 cents on the dollar. And then in between there's a settlement value. And from what Nat's just said, I think it sounds like that settlement value was somewhere in between that value of the asset and the what was believed at one point to believe the Argentina's ability to pay on those assets. A very recent example, there hasn't been any, to my knowledge, there haven't been any claims, but in Sri Lanka is essentially bankrupt right now. And so to the extent that it has claims set against it, you would run into that solvency issue on those claims.
Well, thanks, Lisa. That's great. Please jump in as well at any point if you have further comments on the discussion, and of course we'll have questions. I think this has really nicely set the stage for our next panelist. We've been living, fortunately, unfortunately, in interesting times from a lawyer's point of view. And those who follow this particular area, the idea of mass claims, as in the context of the Ukraine-Russia crisis and the war in Ukraine, there's been a lot of discussion about potential remedies and reparations that might come out of that situation. And I'll leave this to Robert to kind of get into the detail, but just one recent thing that was actually highlighted in the news was, of course, there have been a number of resolutions and actions at the United Nations. And the most recent, just a couple of weeks ago, was a proposal by Ukraine for the creation of a mechanism for reparations. And whether or not that comes to fruition, I guess, is still up in the air, but I'll let Robert jump in and comment on that, because I really think the current events in Ukraine and involving Russia really kind of highlights the importance of these issues in a very concrete and important way. So, Robert.
Thank you, and I think it's important for us to recognize, like Kabir has said, some of the limitations of claims commissions. There's a lot of talk right now about what may be possible. People would like, I think, in an ideal world, to have funds go from the pockets of aggressors over into the pockets of those who have been affected by the invasion. I think that there's a lot of action that seems to be in the direction of trying to make that happen. Certain things are standing in the way. Things like standard sovereign immunity protections. You have right now some interesting discussion. I saw that just a couple of weeks ago, the European Union started talking about recognizing Russia as a state sponsor of terrorism. And that's an interesting development potentially, because the recognition of a state as a state sponsor of terrorism has in the past led over in Canada and the United States to certain implications for sovereign immunity, which might mean that you might be able to enforce certain awards, arbitral awards, against certain state assets that otherwise might not be touched, commercial assets usually in restrictive immunity jurisdictions. Those are the sorts of things that we're facing. The law was not necessarily made for this current environment. And how do you adjust with that? How do you work with that? So this comes to, and I'm sharing my screen here. There we are. Hopefully everyone can see the slides that I'm sharing. This comes to a discussion that we've been having in the Global Pro Bono Bar Association for the last 6 months or so. We have been looking at the likelihood, the possibility of a claims commission that brings the money together across the, I think, 8 different jurisdictions where it's based right now, where some of the Russian assets have been frozen. We see that there are, I think it's been estimated at 300 to 600 billion in one figure that I saw, funds that have been frozen, and yet the need is so much greater. Where does the money come from? Some folks may think, well, gosh, if in the future we continue to add to the frozen Russian assets, then maybe that's where the funds come from. Then again, jurisdictions that might decide to add to that one consolidated pot of claims commission funds might not see any more Russian funds come their way. And so where does the money come from? Here's what I'd like to talk about, an alternative that we've been discussing. In the Global Pro Bono Bar Association, we have about a dozen individual legal academics and practitioners who've been looking at this idea as an alternative, or a supplement actually, to the claims commission process. And I'd like to talk about that. We've kind of assumed that a lot of folks are familiar with this area of law. I think we've jumped right on into it, and I hope that in Washington Arbitration a lot of folks are. Hopefully in the course of questions, people can raise anything that may be something that, even if it may sound like a simple question, that you'd like to ask and clarify. So I'll similarly just jump on into it. There are a lot of bilateral investment treaties, as everyone knows, in force in the world today. In particular, and we'll just jump over the substantive protections and limitations on claims, some of the procedure rules discussions. In particular, Russia has a number in force, I believe it's 63. And you'll see here on the slide that these bilateral investment treaties that Russia still has today in force, according to the UN Conference Conference on Trade and Development, those bilateral investment treaties are with 27 states that Russia now deems to be unfriendly. Unfriendly states are those states that have effectively placed economic sanctions on Russia for the invasion of Ukraine. And so in response, what Russia has done to the states that you see highlighted here are the unfriendly states, as it were. What Russia has done is to place certain restrictions in its own law on foreign investors that hail from those states. Things like transfer restrictions, things like restrictions on debt repayment, non-enforcement of intellectual property rights. There have been a number of measures that have been taken. It would take some time to summarize them all, quite a few. And the question arises then, so one focus here is rightly and properly on the claims commission approach that is intended to get whatever funds there might be, whether they're frozen Russian assets or otherwise, over into the place where they need to be, which is to provide reparations to folks who've lost family members, who have been directly affected by the invasion of Russia. And there's absolutely nothing and no one who would doubt the justice that is needed on that front. On the other hand, it's also true that a costly war is one that may not be worth pursuing next time. And illegal state aggression that we're seeing today, if the cost is greater, well, maybe there's something that's to be said about increasing that cost in a way that will discourage it next time. And so what we've been discussing is a slightly different approach. Okay, let me come down here. An approach in which, rather than using a consolidated claims commission process that will move forward, I suspect, it seems to have a lot of steam behind it. There are a number of countries behind it. I suspect that it will come forward. Going back to Kabir's comments, I suspect that he's probably right again. It will probably have increased voices available. It probably will not reach as far as addressing all the needs that have come from this current situation. In a second effort to advance from where we are today to where we'd like to be, promoting the international rule of law, discouraging state aggression, helping justice to come to those folks who have been affected by Russian economic measures, and in the course of this gotten caught up in the crossfire between Russia's economic measures and those actions that have been taken by other states, imposing international sanctions. We are developing Project Treaty Justice. Now, Project Treaty Justice is a very simple idea. It's not so simple in the diagram here, but basically it comes down to this. Those 27 different jurisdictions, those 27 different bilateral investment treaties that Russia has currently enforced, allow for investors to pursue claims against Russia directly, just like we're talking about here, claims that may be smaller in size. Now, the thing about it is that when commercial practitioners in investor-state arbitration think of investors, a lot of times they'll think of them as the folks who can pay the bill, and that's understandable and human. But what the treaties actually say, and it's been referred to here earlier today, talking about nationality, what the treaties actually say is that a covered investor is the one that actually just has the right nationality in most cases. If you have the right nationality, if you satisfy other criteria with respect to, for example, characteristics of an investment in the ICSA context, then that means that you're able to bring that claim. Most of the time, in many of the old bilateral investment treaties that Russia still has in place from the 90s, from the early 2000s, it's a much simpler characterization than it is today. And that is mostly based on nationality. So going back to those 27 different jurisdictions highlighted before, from the unfriendly states, on the one hand, now targeted by Russia, and on the other hand, still benefiting from the in-force investment treaty protections. The idea here that we're exploring in the Global Pro Bono Bar Association is to reach out to folks who are of limited means, folks who otherwise would never see the inside of the investor-state arbitration framework, just like some of the folks who I suspect were represented in the Abaclat case. And for those folks to come together to develop mass claims based on communities of share ownership, communities of bilateral investment treaty protection, certain other factors that we've been finding are factors that promote tribunals recognizing that it is actually one claim, just with multiple claimants. And to bring those forward in a way that advances qualifying claims, okay, and I mean qualifying claims in the sense of mass claims, qualifying claims that would benefit from civil society to advancing these claims, as opposed to non-qualifying claims that you see here under the gray. Non-qualifying claims being those claims that would probably benefit from the standard commercial practice of law and the standard avenues that already exist. Those two pathways, developing mass claims, qualifying claims on the one hand, and also non-qualifying claims, those folks who may, those businesses that may, those high net worth individuals who may be interested in moving forward with that kind of process, but that probably don't necessarily belong because of the size of the claim, because of the marketability of the claim, that don't necessarily belong in a mass claim pool with investors of limited means who really can't see justice without a mass claims approach. Moving both of those tracks forward with private sector legal service providers, with litigation funders that are participating in the program, and to advance those as mass claims on the right, as you see here at the bottom, and on the left as standard claims in the commercial practice of law. Now, that's the idea behind Project Treaty Justice. And so qualification of this process, what we've been looking at is effectively very simple. A mass claim candidate would be someone who's lost an investment in Russia due to the Russian measures targeting foreign investors as a result of what's been happening in Ukraine, of the invasion of Ukraine and the fallout from international sanctions and from the Russian economic response. And also, of course, where there's access to investor-state arbitration, those highlighted jurisdictions where there's both a bilateral investment treaty that's currently in force and also that jurisdiction has been targeted, the investors in that jurisdiction have been targeted as foreign investors that are considered unfriendly by Russia these days. And finally, that where there's no other avenue for access to justice, like in some of the small claims situations. These are the ideas that we're considering at the Global Pro Bono Bar Association. Objectives here, why would you do this? Well, the purpose of this is not to disturb the great work that's ongoing right now in the discussions around the Claims Commission. To the extent that that can be effective, then that's certainly necessary and important. And the Claims Commission, it's important to say and to recognize, is focused on a certain group of folks, those folks who've been affected directly by the war in Ukraine, by the invasion, those folks who have hopefully been benefiting from humanitarian response and from all of the other response that has been so incredibly overwhelming, I think, wonderful from many countries in the world today. Those folks are the ones who will hopefully benefit from that Claims Commission process. The ones we're talking about here are the others, the investors who've been left over. The investors who may be, for example, pensioners who have lost their funds. I skipped over a slide earlier that shows that in the UK market, there have just been billions of pounds lost from the pension market. A lot of folks, normal folks who've invested in their futures, who are looking forward to a retirement, when suddenly there's a geopolitical change, suddenly they become unfriendly investors, and suddenly their investment in a different jurisdiction, suddenly the investment that they had anticipated relying on for their futures, it's not there anymore, right? These are the folks we're talking about in Project Treaty Justice. The idea here is threefold: to bring justice to those folks I just mentioned, not the ones who are on the ground and suffering from the invasion directly, but the folks who have indirectly suffered through their investments. And then secondly, of course, to deter future acts of aggression by Russia. The idea being that the international rule of law is something that we should promote. And at a time where we've seen the UN Security Council unable to move forward, as has been mentioned earlier today, in the case of state aggression, well, gosh, maybe using other levers within public international law, like the already existing investment treaty architecture, is one way to encourage future international peace and security. And finally, one interesting and helpful follow-up, I think, from this is the democratization of the practice of investor-state arbitration. A lot of times we hear from NGOs and from many academics, in fact, who say that the investor-state arbitration process is an elitist one. It's one that right now has been criticized. Kabir has done a lot of great work around getting support in the investor-state architecture for least developed countries, for example. And a lot of folks will say that the least developed countries are the ones who many times suffer from significant sized arbitral awards that maybe relate to some decisions that have been made in the past. Maybe it makes it difficult to make solid policy changes for the future. It may be related sometimes to the energy sector and for some of the developments that have been coming forward in climate change decisions and such. Those are the sorts of criticisms that have given rise originally to the decision or the discussion that's ongoing right now over in UNCITRAL Working Group 3, where they're discussing the reform of the investor-state system. It's important to recognize that this kind of approach as well, not just in a UN claims context, okay, which is important and first, right? But also in the future, moving forward and recognizing the potential of these mass claims to democratize the practice of investor-state arbitration, which is to say, to make it accessible in some way through mass claims where it's appropriate, like in this context, for common folks who have lost funds that are significant to them, have lost funds that are significant to their futures, and at the same time, don't really have access to the investor-state architecture because of the high costs that have been discussed here today. So that's the idea around Project Treaty Justice, and I think these are both important conversations. I don't want to be heard to say that the Claims Commission process is doomed. I think I may not quite share entirely the negative view that historically that Kabir has shared, earlier. But I do think that it's important for us to look at all the options. I think it's important for us to think about how we can move forward in a way that encourages the future of international law, maximizes the access to justice to the extent we can, and uses the existing architecture that we've got. So thank you.
Well, thanks very much, Robert. That was really enlightening, and I best wishes to Pro Bono for their efforts. That really fills a very important lacuna that's existed certainly for those likely millions of individuals that have been impacted. You mentioned the Claims Commission, and just to put a bit of meat on the bones of how that's potentially viewed, I'm going to put up some wording that was part of the resolution that was recently at the UN. And this is some of the key wording, and it really gets down to kind of some of the process that they're even looking for in that context. You provided an excellent chart in terms of how your group's going to proceed, but clearly the recommendation here is, and I'll use this wording, the creation by member states of an international register of damage to serve as a record in documentary form of evidence and claims information on damage, loss, or injury to all natural and legal persons concerned, as well as the state of Ukraine, but it specifically mentions the wrongful acts of Russian Federation in or against Ukraine. So I think when we're listening to Matthew talk about the incredible level of detail and data that was required, ultimately that's for proving up the number, the damages, because that's what's the case here. So I don't know, just as part of our final comments here, I mean, Lisa, comment on that, because that would seem to be the evidentiary burden would seem to be very high, because this is these would be legal processes, whether you're in an arbitration or in a claims commission, that there is that burden to provide the supporting evidence, and that can look very much like the process we know from international arbitration and commercial arbitration.
Yeah, I mean, you're correct. It is a significant challenge. Fortunately, with building that database helps you start to build potentially, and you probably learned this as you were going through the Argentine case, as the information starts to come in to that database, you can likely find common across kinds of individuals or kinds of entities that then you can create what I often call bucket types of claimants that can then be joined together and their harm can be analyzed. Almost certainly it's not going to be a single group of claimants. It's going to have to be a variety of different kinds of claimants, whether it's what Rob was talking about, the individuals who might not otherwise have an opportunity to make a claim but for the support of the pro bono bar, versus what I think wealthier nations and individuals and companies in wealthier nations that will have an opportunity to make that claim. In some respects, so I took a look in preparation for this panel, I took a look at the damages related to the corn products case and the Canfor case, which is the Canada softwood case. And I think those are interesting to me for two reasons. What the corn products case, where the case was not consolidated, I think when you look at the financial damages there, you can see that the decision not to consolidate in that case was beneficial to the companies, not just for the the confidentiality that they were seeking in terms of disclosure, but I think also in terms of harm, because I think when you look at ADM, Archer Daniels Midland, which is one of the competitors in that potential consolidation case versus corn products, their businesses, even though they're competitors, their businesses are different, and how their businesses were impacted by Mexico's actions were also different one to the other. Corn products, just some of the specifics around that, which I find interesting, is so in that case, Mexico imposed a tariff on U.S. Producers of corn syrup, essentially corn syrup that goes into primarily soft drink beverages, and that's one of Corn Products International's main products. That impacted in the first year it happened in 2004. It impacted Corn Products EBITDA in Mexico by 14%. So they had a downfall in EBITDA of 14% in that first year. Corn Products ultimately reacted very effectively to that tariff and closed down their Mexico factories and moved that production to nearby countries. And from those factories in nearby countries, were able to provide their product into Mexico. So from a financial perspective, they actually recovered reasonably well, but they ended up winning on both fronts, because they ended up making a claim for, at first, in 2005, the claim was established to be $250 million. And then in 2006, they increased the value of that claim to $350 million. They ultimately won $54 million, which is actually a very good outcome, given that they really only had about a year and a half of impact to their company in terms of financial harm. So I think that case is really interesting, both from a thinking about the quantification of damages, but also what the company did effectively to mitigate its damages.
Well, thanks, Lisa. Before we get to questions, which I want to move to next, Kabir, I can't go to finish this without mentioning Robert's little challenge to you. Are you skeptical about claims commissions? Is this your view?
Yes.
I know you indicated a little bit there, but how about the prospects for a mechanism in relation to the Ukraine crisis?
Almost impossible, and if it does happen, very dangerous. That's my big takeaway. I feel just look at history. We're sitting with the UKUS award. Good luck trying to enforce that. I mean, that may be a unique reality for the respondent state here, but we need to be thinking realistically about all the avenues we are assessing. But putting that aside, this idea that some countries are going to get together and freeze countries' assets can lead to reciprocal treatments. And that seems to me to be an inherently dangerous idea. Today, if the US and Europe freeze Russian assets, tomorrow, Russia and China are going to freeze US assets. And that just seems to me the creation of World War III, something we're really trying to avoid. So while these seem, I also just point out, we're right now, and this is getting technical, but everything that we're talking about right now is happening in the General Assembly. This is not a General Assembly issue. This is a Security Council issue. Russia is part of the Security Council and has a veto. The rules are the rules. When we start changing rules to address situations that warrant change, but are done in quick reaction to situations, good things don't come out of them. We need principled objections. What we're seeing with Russia, it's not a new observation that the Security Council is a flawed body. So I just do put it out there that all of these sound like incredibly dangerous ideas, coming from good and well-intentioned places, trying to respond to something that most decent people feel we need to respond to. But we may be leading ourselves into much more dangerous things. So that's my view here.
Thanks, Kabir. I knew you'd always give us your unvarnished opinion. Matthew, before we go to questions, give you a chance to respond on this as well. You've been somebody down in the trenches on these types of issues and lived and breathed them. And now we're faced with potential claims commissions, and as we see with Robert's group's effort, potential mass claims. What are your thoughts?
Yeah, I mean, I think one of the things that is a starting point, because we saw and heard from Lisa that at the tail end, you really are going to need to have everything in a row. You can't get to this point with high, lofty ideals without having the underlying information at hand that you have, not only in as much documentary evidence as you can gather together, but also organized in a coherent manner that's usable by whoever it may be, whether it's a established claims commission, whether you go to a tribunal. I mean, without that, you will be stymied at the stage of perhaps there's something you want to do, but in order to afford due process to all parties involved, which is really, again, to go back to one of the first things, that's the whole purpose of this. Every party is allowed to have due process. They need to be permitted to challenge evidence. They need to be permitted to argue that the valuation is off, or that the individual is not a qualified individual. If they're not provided with the evidence to challenge, then you don't satisfy that standard as well. So really it goes both ways. A lot of this is viewed from the claimant side and whether you can initiate mass claims, but at the same time, you have to remember that this is a two-sided thing, and to, not leave due process behind. And so it's something to keep in mind.
I have a question for you, Matt, and maybe this goes to Rob as well. What are the things that I think about with regard to the Ukraine, an issue in terms of data collection is almost surely going to be that you're not going to know all of the information at the onset, all the information you need to know for the time at which you ultimately get to a settlement. And so there's a real challenge there in terms of layering, of gathering of information. And it's hard to go back to the well again and again.
Yeah.
What's been your experience in that regard?
I mean, one thing we saw, and I mean, again, Kabir may also weigh in on this too. I mean, this has been an issue that's been faced by many of these claims commissions. I mean, the UNCC out of Iraq, anything that's dealing with with claims arising out of wartime or fighting, you're always faced with, sometimes you have more solid documentation or identification of what the harm suffered was and what the value was. And then other times you don't have that at all, either because it's been lost or it's been left behind or it's been destroyed. And I think in looking at the way prior claims commissions have done things, is they've, again, and goes to your categorization of buckets. You have different groupings of individuals or companies or affected people who have different levels of evidence, and then you can deal with them in a sort of a staggered fashion. You're going to be able to deal with some that have documentation and you can address those, and then you work your way down to a standard or a way to, again, handle ones where you don't have that same type of thing. You're not dealing with everybody in the same form. And that was the case in private arbitration, and in the Avoclat, there were different people with, but there it was very standardized. I think here you need to deal with a lack of standardization, and how do you come out of that? So and maybe Rob has already started thinking about that in their capacity in the Global Pro Bono project. So,
well, the comments you're making are important, and it's obviously correct and true. I think that one thing that our researchers have been finding to be the case is that if you look at shareholder communities, that's probably the best initial starting point, because in shareholder communities you probably do have a little better sense of the value of the loss, even though there would still be expert advice that would be required, expert reporting that would be required, and at the same time you also would have a little better sense of whether it's likely to be a successful mass claim, because a lot of the concerns that have been arising in some of the cases, like Avoclat, 60,000 different bondholders. Right, that's an amazing case, and hats off to you. That's amazing. At the same time, making mass claims in this context move forward, I think within shareholder communities, I think that there's a great deal of potential, because the fact is that within those shareholder communities, provided that the ultimate investors have the right nationality, and obviously that the relevant bid doesn't have, or other international investment agreement doesn't have any concerns or barriers for indirect shareholding, which is often the case, of course, then that means that a lot of the records that you'll have will already be in the hands of corporate management, readily available. A lot of the evidence will be there. It's not going to be, I think, maybe as much of a challenge as the amazing one that you and your team met in the appliqué case. At least let's hope so. But I think there's a great deal of potential, and I think that some of these ways of approaching this, the scale is so great that there's a great deal of potential to find the best case and to move them forward. I think that's what I would say on it.
Well, thanks, Robert. I think we've got a few minutes if there's some questions in the audience, either online or in the room. A couple over here, Stacy.
Hello, thank you for the wonderful panel. I wonder, did it make sense in Abaclat or in other mass claims to import the concept of class certification that you have in antitrust cases, and how that would work procedurally? And did you go through that process in an informal way, if not for the class certification itself?
Yeah, I mean, class certification was something that was or discussed and thought about, but really in the US context, class certification arises out of the specific rules that are available in the Federal Rules of Civil Procedure and the power of US courts to dictate that representative group. And the issue you face in arbitration, and in particular in ICSID arbitration, is, one of the fundamental tenets is consent. And so you had to establish, you couldn't just take a bellwether group, 10, 20, whatever, 100 people and say these qualify nationality consent wise, and then apply that to 200,000 people. I mean, there was, you could think about maybe making that argument, but I think you really run into a lot of problems. And again, go back to due process. And then this idea, Argentina's main point was, we did not consent to this. And if you can't show that, claimant 100,099 was an Italian national that held a bond that was purchased before 2001, Argentina arguably didn't consent to, arbitrate with them under the US-Italy bid, or the Argentina-Italy bid. So the idea of class was something that doesn't really work, I think, in the ICSID context, and it really boils down to consent. And one of the reasons we went through all of the procedural steps and detail and verification steps to show that what our people had were individualized evidence of consent, nationality, and holding, and the time of that in order to overcome that hurdle. So.
That was a really good question. I mean, the sort of distinguishing feature between arbitration and litigation, whereas courts are, a function of, part of the government, right? It's kind of a top-down ability. The powers there just don't exist in arbitration. It's all in the specific instrument, like the treaty. So NAFTA allows for it, but that's because it's there. And so the consent is baked in. If you bring a case under NAFTA, you're accepting those provisions. And that's just not the case with most treaties. It's just not there. One more question.
Thank you so much for this very genuine and very entertaining presentation. I was wondering, I have a question with regards to practical takeaways regarding the interplay between different legal orders used to deter Russia for this war. So you work extensively on this project, which I never heard before, I must admit. But there are some initiatives at the EU level of establishing a tribunal in order to punish those who started this war. You added a violation of sanctions to list of EU crimes, I think 2 days ago on November 28th. And of course, there's this initiative about establishing an international anti-corruption court, which is going to be debated at the Embassy of Netherlands next Monday, which gather immense international support in this context. So how could we use your best practices from arbitration and transpose them in under the UN conventions, because they are related to corruption, to the failures to uphold the rule of law, And there may be mechanisms, because with the assets freezing and respecting the rule of law, there's no problem. I see this as a kleptocrats, and the standards, at least at the European Court of Human Rights, is to provide them access to justice, allowing them to present a defense and identify who the beneficial owner of the structure is. And it was very nice in practice. It's difficult indeed to transform information in investigation data and then in evidence, but it's not impossible.
Kabir, I guess, and then maybe Robert, if you have a comment on that.
Sure.
Thank you.
Let me make two reactions. The first point, most of the international regimes that are out there are weak. This is by design. The entire international regime is premised on notions of consent. It presents all kinds of problems. A lot of the initiatives you're talking about are actually at very early stages, but for all of them, you need consent, and states can give consent, states can withdraw consent. Nothing can happen unless the state really doesn't consent, especially if you're talking about larger states. What could be done? You could use interpretative techniques to try and make different regimes talk with one another. That is probably as good a regime as we potentially have in front of us. So if you want arbitration rules to inform human rights rules, or vice versa, it should actually be vice versa more than the other way. But if you want that dialogue to take place, you know, the Vienna Convention, Article 31(3)(c) empowers a decision maker to consider other rules. It has been applied woefully inconsistently and unsystematically by decision makers across regimes. But that is potentially an avenue or an option that we can adopt. I do put it out there, you can get symbolic victories. If it's a smaller state where Security Council bodies are not involved, you may be able to get a Security Council resolution. But the reality of the day, and we just have to accept this, is the rules are not fundamentally fair and are not strong. I mean, that's just the international regime. We have to take it for what it is worth.
Well, I don't want to quite leave us with that bit of reality, but Robert,
yeah.
I'll give you the last word, and maybe you can, have a little more uplifting.
Let me bring
a
positive view.
Bring us home.
So it's true that in international law things move slowly. I think that's the way I'll say it. I don't think it's hopeless. I think things move slowly. So, for example, and this is not in the course of what I'm here to talk about with the Global Pro Bono Bar Association, but just in the course of my own practice, I've had an opportunity myself, just to give you an example, to advise a sovereign state over in West Africa on bringing together the regimes of business and human rights and the environmental protection and investment protection into a new model bilateral investment treaty. There are some 60 others. I'm not saying it's absolutely unique, but into a new model bilateral investment treaty. You can find it on the internet if you like, the Sustainable Investment Facilitation and Cooperation Agreement, or SIFCA. And the idea of that is to start, it only provides jurisdiction over violations of internationally recognized human rights abuses arising from that investment if an investor brings a claim against the state. So it's not a panacea. It's not something that makes suddenly overnight all business and human rights principles applicable or environmental protection applicable in any meaningful, strong way. But it is a beginning where when we start talking about investment protection, we also think about and start talking about business and human rights and environmental protection. I think that those incremental steps, a lot of the changes that we're seeing right now, treaty changes, conventions around, the discussion of climate change, these things over time will start to coalesce into, what a lot of academics have referred to as regime interaction, where you see in public international law a change here that starts to affect a separate regime here that can, through efforts like this, slowly, painstakingly over time come together. There is hope at the end of the tunnel. That's what I'll say.
Well, I think we'll finish on that note. I just want to thank all of our speakers today, Kabir, Matthew, Lisa, and Robert. I think that really helped provide some great background as to kind of the history and the practice that has grown around this important topic of mass claims. And Robert has given us a great example of some excellent work that is going on in real time to address some very, very real problems that along with hopefully perhaps a claims commission, and we'll see how that develops. We're definitely living in interesting times. So thanks to everyone. Thanks to our audience.